Good morning. I wanted to welcome you to this podcast that I'm doing with my colleagues here. My name is David Yang. On my right is Bart Daniel. On my left is Matt Austin. Just a bit about me. I practice government contracts out of the firm's DC office. I've been doing government contracts for about almost 20 years, and my practice is, I would describe it as sort of a full spectrum, so I deal with a lot of issues. Bart, you want to?
Yeah. Bart Daniel, and I served as a federal prosecutor. I was hired actually with the State Attorney General's office right out of law school on an economic crime grant. I did that. Then my boss got hired on as the head of the criminal division, the chief of the criminal division at the United States Attorney's Office for the District of South Carolina. And he brought me over some 6 months later, and I prosecuted initially all financial crimes associated with drug cases and also tax cases and other financial crime cases. I did that and then went into private practice where I did mostly the same thing, but just on the defense side. And then in 1989, I was appointed United States Attorney by President George H.W. Bush, the first Bush, and served as United States Attorney for a little over 3 years. We prosecuted all sorts of cases, public corruption cases, and we didn't have cybersecurity cases back then, but we had cases involving fraud that were very similar. So that's been my career ever since. I left the U.S. Attorney's Office for the second time, went into private practice, and I've been in private practice doing exclusively False Claims Act cases and defending white-collar cases.
And I'm Matt Austin, here at Nelson Mullins as well, doing mostly white-collar criminal defense and government investigations, with emphasis on healthcare fraud, defense of key TAMs. Just a little about my background. I started out actually in law school working for Bart, and that's where I was kind of exposed to this whole area of False Claims Act work, really in the healthcare arena. And so I started out as a state prosecutor here in South Carolina, and wanted to try to figure out how to get into the U.S. Attorney's Office to get involved with healthcare fraud cases. And so I went back to school at night to get a master's in health administration, which I then sort of parlayed into doing healthcare fraud at the U.S. Attorney's Office. And so I was there for about 7 years in the Charleston office, just a couple of floors below us now, and for 7 years I prosecuted white-collar crimes, financial fraud, healthcare fraud cases, and then was lucky enough to be cross-designated to handle criminal and civil False Claims Act cases in the healthcare arena. And so did that 7 years, and I came up here to Nelson Mullins and been working with Bart in the same kind of work ever since. And so it's a lot of fun. It's a fruitful area.
All right. So, the cybersecurity requirements that have been issued by the Department of Defense, it's not a new topic. It's a topic that has been in process for a number of years, and it's gone through various iterations of what it was and now what it is. And so we decided that there's a need, I think, for contractors who are operating in the DoD space to understand not just what it takes to become compliant with the requirements, because there's plenty of coverage from many different sources about that. So we are going to take a slightly different spin on that intersection between cybersecurity and False Claims Act, mostly focusing on what happens not so much on the front end when you're trying to set up the system, but really kind of during the middle part where you started, you haven't finished, and then also on the back part in terms of maintaining compliance, because I think there has not been as much dialogue or discussion within industry about how do you manage risk profile. Even if you've done everything right, or you think that you've done everything right, what are the issues that general counsels, compliance teams need to really understand what the potential ramifications are. So that's really going to be kind of the focus of what we are going to be talking about today. But I think it might just be helpful just as a really quick refresher about where we are today with cybersecurity requirements. So for years, DoD has been dissatisfied with the current cybersecurity requirements, which really relies heavily upon self-certifications and self-assessments by contractors. They just didn't really find that to be, that reliable or consistent. And so this move to what we are now calling CMMC, which is the cybersecurity, maturity model certification program, is really to move away from self-assessments to third-party assessments. So now you're going to have a third party come in, whether it's a private third party or it's the government come in, and they were going to audit your system to see like where your gaps are in terms of your cyber compliance requirements. So that is the real kind of genesis and the purpose of that. And we'll talk about a bit more about like pros and cons, of this new system. But at a high level, there's going to be 3 levels of certification. Level 1, which is like the lowest certification level. There's going to be level 2, and within level 2, there's going to be self, and then also third party. And the difference between that is what kind of information are you handling? So I suspect that most contractors are going to be dealing with what we call controlled unclassified, information, and which we call CUI. And most contractors are going to be seeking to get certified by a third party because the type of CUI that they handle are going to be deemed to be more critical to like the national defense. And then there's level 3, which is the highest, which includes all the level 2 stuff, plus some other enhancements. And these audits are going to happen like every 3 years, and so it's very labor intensive. It's very complicated, but that's kind of where we are. In terms of where we are in terms of the regulations, now the actual substantive regulations have been effective since last December of 2024. The actual clause that is going to implement these requirements into new like RFPs are going to be effective starting from November 10th. We'll see what happens because the government's shut down right now, so there's not much activity there. But that will be the effective date, and it's going to be a phased rollout approach, and they're going to start with like the low-hanging fruit. So it's going to be level 1 cert and level 2 self-assessment, and then eventually they're going to graduate to level 2 third-party certification, and then level 3. So eventually everything's going to be covered. And so I think a lot of contractors are already on that path because they've been aware of this for years, right? And so on the front end stuff, we see that. Well, I see that more as something that consultants do. I think we're going to be focused more, as I mentioned, on what happens when you started the process. Things happen along the way. Things don't get caught in time. There are mistakes that are made, and how do you deal with making sure that a mistake, in your compliance program and any kind of related certification does not bleed over into something that's more, dangerous, right? So that is the sort of overview on that. And
so I also just to jump in real quick, just to add, just to sort of set the table here a little bit, with where this comes in with the type of work that Bart and I do in the False Claims Act arena. I think you're right, but my sense as I've gotten into this space more and working with DoD contractors is everybody's familiar with CMMC requirements, but one thing that I've noticed almost to a person is that they're not familiar with the False Claims Act and what could happen if they're not compliant once these deadlines arrive. And so just to kind of like give a sense of scale, I think everybody knows there's a lot of money flowing from DoD out to contractors, but it's fiscal year 2023 alone, there's $28 billion in progress payments, $22 billion in performance-based payments. And so what that means is there's a huge target on contractors' backs by whistleblower lawyers who know that these certification requirements are in place, and also that most contractors may not be fully compliant, especially as you get further down in the subcontractor space. And so as I've been learning more about it, it's just been really interesting to just see that how vulnerable everybody is, because up until now everyone's worried about fines, which is just sort of the cost of doing business, I think, in a lot of people's minds. But once you start getting into key TAMs and False Claims Act world, things can really add up. And, with treble damages and all the, the tools available to the government, we'll cover later in this talk, there is potential for massive recoveries against firms that really are not getting, up to speed with everything and getting compliant immediately. So I think if it makes sense, now we'll go into the False Claims Act and just give a little primer on that. Bart's been doing it for years, so he's the perfect person for it. And so I'll turn it over to you, Bart.
So picking up on Matt's laying the table or setting the table, I had an old salty lawyer when I first got the Department of Justice tell me when I was doing some legal research. He said, Bart, he said, you can spend time in that law library if you want, and that's good, and it's healthy, and it's good for your cases. But it's more important sometimes to understand the history. A page of history can be worth volumes of law. And it turns out all these years later, he's been proven right time and after time and again. So let's go and turn our books back, the pages back in history to the Civil War, because that's the inception of the False Claims Act case. The False Claims Act statute was passed because Congress and President Lincoln got fed up with contractors selling, defense contractors selling faulty munitions to the government. Simply put, they were duds. They wouldn't go off or they would explode prematurely. So what the purpose of the False Claims Act was to enlist private citizens to help it ferret out fraud against the government. The result, particularly after the 1986 amendments, and those amendments are the key, 1986, and we'll talk about those in details in a few minutes, but it exponentially expanded the number of cases reported and the total dollar amount of recovered. But it also, incidentally, gave birth to a cottage industry of whistleblower or related lawyers who do nothing but False Claims Act cases, and they, across the country, they seek out potential relators and enlist them, potential defense contract employees, healthcare employees particularly, and convince them to become relators or plaintiffs in a key TAM in a False Claims Act case. So what's the process? What's the procedure for it? Well, you have a private person who files suit on behalf of the government. Many times these private litigants who are bringing these cases for the government are employees who secretly gather information while they're employees and then secretly bring a case. The suits are known as key TAM, and you heard of me talk about the plaintiffs as relators because that's what they're called in a False Claims Act case. The complaint is filed under seal, it's secret, and nobody knows about it. The defendants may not find out about it until it's unsealed, sometimes 2 or 3 years later. But normally, by statute, the government has 60 days within which to investigate the False Claims Act. And then they make the decision, the government makes a decision whether they're going to intervene or not intervene. That means take over the case procedurally. And the lawyer in the case steps aside, and the government takes over that case and moves forward with the case. So when that happens, though, it's always the government's case. Sometimes the government declines to intervene, and they may decline to intervene early on, and then later jump in the case and take over the case. The government is in charge. The relator only steps in the shoes of the government. So at the end of the case, even if the government has not intervened, and the relator gets a whopping judgment in its favor, it's not in the relator's favor. It's on behalf of the federal government. The full recovery, the full settlement goes to the government. And then the government decides how much are we going to give this relator. And it's anywhere between now, it was raised in 1986 amendment, it's raised, now it's between 15% and 30%.
Bart, it's fair to say that the whole point of this is really to enlist citizens to help the government where they can't have an agent looking every single place. And so basically expands the resources of the government.
Yeah,
Right?
and it's proven to be true because you have many more cases that are filed to relators versus those cases that are investigated or filed just by the government with no whistleblower or no relator involved. So why do we expect to see increased enforcement in the compliance of cybersecurity enforcement? Well, again, going back in more recent history, the case of the notorious bank robber Slick Willie Sutton. Willie Sutton was a notorious bank robber who robbed banks for over 40 years. He would rob a bank, and when he robbed the banks, many times he got caught. He would be imprisoned. He would escape from prison and go and rob banks all over again. And this happened, he escaped 3 times only to get out and rob banks again. And when he was finally caught, he was shouted out, reporters shouted out to him right when he was walking into his final sentence. And the reporter said, "Willie, why do you rob banks?" And Willie says, "Simple, because that's where the money is." And so, like Slick Willie Sutton, the Department of Justice and these whistleblower lawyers follow the money. So Congress also, as a result, when they've received so many recoveries, has committed additional resources, and these resources are tremendous, to False Claims Act enforcement. They've funded new agent positions over the years, additional federal prosecutor positions over the years to prosecute these cases that the agents investigate. And the return on investment, it's been a good deal. The government gets, in 1 year alone, they receive $9 for every dollar the government expended on its investigations. And most years, it's between a return of between $5 and $6 for every dollar spent. DOJ, I think Matt mentioned that DOJ paid just to defense contractors some $50 billion in fiscal year 23. By the end of fiscal year 24, the Department of Justice had recovered $2.9 billion. That's billion with a B, from False Claims Act enforcement. And that's likely going to increase in 2025 at the expense of, you guessed it, government contractors. So how does it work? When a contractor files a request for payment after performing work for the government, he's got to certify that he's complied with the cyber security requirements. If he's not, if he files that claim for payment and the contractor is not in compliance, full compliance with that cybersecurity compliance, then the request for payment is tantamount to or equivalent to a false claim. And the penalties and damages are draconian. It's, first of all, it's automatically tripled or trebled damages. Secondly, there's penalties per claim, which began when it first was enacted as $5,500 to $11,000, and now has jumped up, because it's indexed to inflation, to $14,000 plus some change to $28,000. But in addition to that, the defense contractor will have to pay the full attorney fees of the relator. And if the relator is an employee, they may have to hire that employee back. So the employee gets a percentage of recovery and may get hired back, and there may even be a retaliation component to it if the employee can prove that. And finally, at the very end of it, the contractor may face suspension or disbarment. That means if it's the contractor's debarred, it means the contractor can never perform government work or subcontract work again. So we mentioned the 86 amendments. What did the 86 amendments do? Number one, it lowered the burden of proof from clear and convincing to beyond the preponderance or greater weight of the evidence. Just very similar to a normal civil case. When I prosecuted fraud cases before the enactment of the 86 amendments, that's how you prosecuted civil fraud cases, under a fraud statute with its accompanying 9 elements that the plaintiff or the government had to prove. Secondly, it established liability for deliberate ignorance or reckless disregard. We used to call it the ostrich defense. You can't say I was too busy complying with the terms of the contract and I just didn't have my mind focused on complying with these certifications. That's not a defense anymore. Then it imposes, we talked about, the treble damages, treble damages and damages per claim. And then it increased the reward, which I've already referred to relators, up to 15% to 30% award. And then in 2009, it amended the intent requirement. You don't have to intentionally commit fraud when you request for payment. And you only that conduct only has to be material to the claim. So, contractors beware. Cybersecurity is one of the top 3 enforcement priorities at the Department of Justice. It gives healthcare fraud, pandemic fraud, and now CMMC fraud. And as the pandemic fraud cases dwindle and dissipate and eventually disappear, those resources the government has are going to go into investigating and prosecuting compliance fraud.
And Bart, I was just going to say, just to sort of give a high-level view of this, when I think everybody intuitively understands when you say DOJ is pouring resources into something, but just to sort of put a finer point on it, DOJ is largely comprised of young, ambitious prosecutors that have worked really hard to get there and see it as a stepping stone for many to get into bigger roles afterwards. And so everybody wants to have that big splashy case that they can point to and that they handled the biggest healthcare fraud case or whatever, and say that there's $1 billion recovery, and it's ultimately great for marketing and for their career. And so and when we talk about resources being put in, it just needs to be understood that that's what you're looking at. You're looking at smart, ambitious people that see opportunities in these cases to make a name for themselves. And same with the relators bar. And so it's not just sort of filler political puffery. I mean, there are real world consequences to this, and so it's something to be prepared for. And it's
also real money we're talking about too,
right.
which is the biggest incentive of all.
Yeah. I mean, the Relators Council look at these cases as potentially being their lottery ticket and get out. I mean, all the tobacco cases are probably the most famous example. I mean, there are multiple billionaires that have yachts parked out here in Charleston because they took a risk on those cases, and so it's there's a roadmap that's well established, and so it's I think it's just important to keep that in mind. And Dave, I'm going to go into basically explain. You can sort of break down more how this all intersects. The cybersecurity stuff and False Claims Act work.
Yeah, no, sure, be happy to. So, cybersecurity, I think, is one of these apolitical topics, though I don't think it's going to change whether it's the Trump administration or another administration. It's a priority for for the nation, for national defense interests, especially when we're talking about handling this type of critical, controlled, unclassified, or even higher levels of information. Right, like we have adversaries all around the world. We're neck and neck in competition with China. So all these consulting companies that are helping DoD and related activities develop AI, how to deploy that technology to the warfighter. There are all sorts of sensitive topics, right? And so cybersecurity, I don't think, has ever been more important. I think, in fact, if you go back 40 years ago, and we're talking about, more conventional, right? So if we're building, not building, but if we're making shells or bullets, right? Things of that nature, or it's certainly sensitive, but it's not as sensitive as like cutting edge AI. It's one thing that to be doing something that is more of what we would now call a widget versus something that is going to be as a prototype, or you're going to have a Navy SEAL or a Delta Force guy, right, in the field, and he is going to have prototype stuff all over him. And so these are the systems that are being developed right now. And so this is why I don't think it's going to change. But just kind of going back to Matt's question, like, why does this matter? And like, why does the new system that we now have in place, I think, increase or has the potential to increase your exposure under the False Claims Act. So under the prior system, there's always been a clause in every DoD contract. But that was largely done by self-assessment, right? It was an internal company thing. And there was no certification. Now, you could bring a case under the FCA under what we call the applied certification theory, right? Where it is assumed that there are certain clauses in a government contract with DoD that are deemed to be material, right? And the Supreme Court has to find that as, and I'm paraphrasing here, but as a sort of natural tendency to pay or not pay, right? So hypothetically, if you breach the contract, the question for the common person would be, well, if I had known that, would I have approved this invoice, right? And that's kind of what that was deemed to be. So now, though, we have an express certification. So we don't need to have any kind of guesswork anymore. We have an express certification where contractors need to put their own self-assessments into various systems that the government can check, annual certifications, and also, they're going to be assessed, right, by either a third party or by the government itself. And so the reason why I say that it can potentially increase a contractor's exposure is that if you follow every single step that your third party assessor says, and you implement that plan, and you're correct on your assessments and certifications, then that's a great shield. It's a great shield, right? Somebody wants to bring a key tank case, like Bart was saying, that would be your biggest offense. It's like, we've been audited, right? This was the plan. This is our this is our approved internal cybersecurity plan. We're following it, right? So we have the records. We're not self-assessing this. This is a third-party experienced consultant, right? And these third parties have to be licensed. So it's not just like anybody off the street.
You've got suspenders. You've got everything in place.
Exactly.
No.
So it can be a great shield, but it can also be a sword, because let's say you're a contractor, okay? And unfortunately, I think there's a large swath of the contractor base that are not compliant, okay? And there can be many reasons for that.
Can I jump real quick?
Yeah.
I just in speaking with friends in the IT industry, their estimate, and this is anecdotal, so it's not exact, but almost everybody I've talked to says their estimate is over 90% of their clients are not compliant, and I mean that is to a person. It's really been remarkable. So I'm sorry.
No, absolutely. So everyone's trying to play catch up, right? Because once these new RPs are issued or options are extended, as a business, of course, right, you are going to want to be able to participate in those opportunities. So is it conceivable that you're going to rush certain things to be eligible to bid? So when we think about what you're doing from cyber, it's the entire procurement process. So everything from what you're saying to the government customer in your proposal, to once you get the contract, to while you're performing the contract, if you make a misstatement, that could be deemed to be a false statement that could lead to a false claim, right? And so you need to be very careful, and there is going to be an inherent tug of war between sales and compliance. And sometimes there's miscommunication, or there's not enough coordination where everyone is on the same page. And so that is, I think one of the biggest things, because once you put something down in a proposal, and it can vary. I mean, there are some RFPs that say that you must certify that you are already compliant. There are others that say that you need to be compliant by the time we award the contract, right? And so, but the point though is that if you are saying one thing and you can't live up to it, at the end of the day, there's going to be exposure, right? And I think the other thing that's really important is that, just kind of going back to how this is a sword. Let's say you have a third party assessor. They come in, right, and they do like the gap analysis, and they give you a score as to where they think you are, right? I think like the lowest score is like negative 243, and the highest score is in the 100 somethings. Okay, so let's say that you don't agree with that, and you don't follow their recommendations, and you put in like your own score. And without getting too far in the weeds, there may be reasons why you want to do that, because for companies that are not fully compliant, there are circumstances where they can get what's called a POAM, which stands for Plans of Action and Milestones. It's basically a schedule of when you're going to fix all the issues, right? And so you typically have a certain number of months to fix that before you are deemed to be fully compliant, right? So what happens is that there could be two problems. One is if you put in a score that gets you to a point where you can actually say, I have a POAM, right? And so therefore I'm conditionally certified, when that baseline score is something that you have made up as opposed to the third party assessor, right? That is going to be a inconsistency, because that undermines your entire basis for why you're only conditional. Two, once you have the conditional, that doesn't mean that you can take your foot off the gas. You need to actually complete or get an extension of each one of these gaps, right? Because once that time period expires, then you are no longer certified at all. So while you might be compliant, on a conditional basis when you get the contract, there's going to come a time, and during that, maybe six months out, when that conditional certification has now expired, and so you're not certified at all. And if you keep on submitting claims, those are all false claims.
Yeah, and I mean, it really goes to the knowledge requirement, right? So if you're a relators counsel and you're looking at building out a case, one of the biggest things you have to show is the knowledge piece. What did a person have in their mind? And you have to show that they knowingly submitted false claims. And so, I mean, here, the longer you go with things being put out there, you have these obligations, when they come due, and if you don't do anything, then, I mean, what's your excuse? You can't say you didn't know about it, and the Relators Council will be just licking their chops.
And it's a well-traveled road, because the healthcare industry they have to be certified that they're compliant. They have a healthcare compliance plan. They have a security, all these compliance issues that they face. If they have that plan in place, as Dave mentioned, and they don't follow that plan, then it becomes the sword and not the shield. It offers no protection, but only opens you up to vulnerability and liability.
Also, as Bart mentioned earlier, if it wasn't hard enough, just for the prime contractors to have to get, compliant, they are responsible for their whole supply chain as well, right? So if you have a vendor subcontractor that is going to be hosting the kind of data that needs to be protected, then that subcontractor also needs to have the same level of certification that is required to host that data, right? And ultimately, if you don't do your diligence as a prime and you have a non-compliant subcontractor, that gets both the subcontractor but also you as a prime, because you as a prime contractor are the only ones who privy with the government, right? But that increases an additional level of risk, right? So there's lots of moving parts. That's why everything. I mean, people are rushing to get certified so that they can be ready to bid on big procurements that are going to be coming out. And it's all part of their overall plan, right? So every company's going to have this year we're going to target 4 or 5 large procurements. It's going to be strategic for our business in these areas, but we need to get compliant, and working that problem is not something that you can just do in 24 hours, right? So it's really about a good coordination between the folks on the ground that are doing the work, but also having management really be involved and making time for it, and making sure that everybody is in lockstep and being realistic as to when we can actually be compliant and whether what we're saying is true, right? because that will all kind of come back if it's not.
And I would say, again, kind of going back big picture, we talk a lot about risk. It's like risk of what? And there are different risks at different times. And we talk about these DOJ initiatives. At the end of the day, there's got to be a decision made by an AUSA as to whether or not they're going to, take over the case or not, or if there's, going to be a criminal component or whatever. And so, just a practical reality of life as a prosecutor is you have limited time and resources, and so you have to make judgment calls on what you're going to focus on. And what you don't want to be is a DoD contractor who's in a situation where their file has made its way onto a desk of an AUSA, and they're trying to make a decision one or the other, and they've got other files on there. And when they look in there, if you see one contractor who is making, maybe not fully compliant, but they're making all these attempts to, it's not just, window dressing and they have a compliance plan, but they're not following it. They're actually doing the things that gives the impression and makes the case that they're actually trying in good faith to comply. And then there's another file, and there's people just cutting corners and just basically just trying to, just skirt the system. That's an easier call for anyone to say. And so it's, you're never going to be completely safe from vulnerability. We're all human, mistakes are made, but hopefully you just haven't made as many mistakes as somebody else. I mean, it's if you're
absolutely, yeah.
So,
it's a scale, absolutely. Also, I'm curious about your views on when companies might also have to be considering, do I have some kind of disclosure obligation? So under the current cybersecurity regulations, if you have a cybersecurity breach, you're required to disclose that and report that problem. And so there is, and that's not a new requirement. But if you think about it, does a company have a broader obligation while they're investigating why the breach happened, right? To say, hey, do we also have a mandatory disclosure obligation, which is a separate requirement, under the FAR, which is the regulation that governs, pretty much all, government contracts. And that standard is, you are required to, on a timely basis, disclose credible evidence of any kind of potential False Claims Act, right? And so I don't think it's enough to just follow the cyber incident response report. I mean, you will be certainly doing, your internal investigation as to how that happened. But I think that there's two audiences, right? Because with the mandatory disclosure stuff, that's going to go to the IG. With the cyber stuff, it goes to, different folks. So you need to understand what you're doing and to which audience, and make sure that your stories are aligned. And I think that's the point where counsel becomes invaluable, because you don't want to over disclose, but then you don't want to under disclose, because if you don't disclose, and you should have, you're going to lose credibility. 1, 2, there could be consequences, right? And so I think.
But I was just to say, if you file a claim and you're not fully compliant, that's a false claim, and you have an obligation within 60 days to repay that money to the government. Whatever was in the claim, you've got to refund to the government, because it was a false claim. You were not compliant with cybersecurity requirements.
Well, and how you go about disclosing things too really matters. And to your point about counsel, it's no shocker we're presenting this podcast and this webinar because we want to try to get business in this area, but it really does matter to have somebody who works in the area and knows the people and knows how to convey the client what's going on with their situation in a positive light and not in a dishonest light, but understanding what information needs to be conveyed, how to do it, and how to show that you're acting in good faith just matters a lot. It goes back to how are you going to be presented as a potential target to somebody in a decision-making position. I mean, it's human nature. And so it's, hopefully everybody tries to hire us if they need any help with it, obviously. This really goes back to the DOJ initiative, or DOJ emphasis right now. I mean, it's real, and there's already been, a lot of groundwork done in the healthcare arena in particular, as I mentioned. But just sort of so the audience understands, in 2021, on the heels of a bunch of ransomware and cyber attacks, DOJ announced this cyber fraud initiative to really, make an active, concerted effort to address this area, and it's produced a number of just great cases already that really should serve as a warning to anybody in this industry that may not be compliant. But the problem is, it's just most people are living their lives and don't necessarily pay close attention to it. But it's a cross administration initiative. I think Dave mentioned it being very apolitical in nature. I mean, everybody agrees that cybersecurity and government's important secrets issues is it's something to be safeguarded.
There's no debate on it.
Right?
Yeah.
Yeah, it's easy.
Yeah.
And that's why that knowledge piece of it is just so important, because if you have these obligations and you're not compliant, then it's tough to explain. So I think that's maybe a good segue into the case summaries that we talked about, which I think I'm about first here. So first case I wanted to talk about was it's called Hill ASC or Hill Associates. It's a Maryland-based IT services company that worked with federal agencies, and they just settled with the government in a False Claims Act for $14.75 million to resolve allegations that it violated the False Claims Act in connection with a GSA contract for tech services or IT services. And basically what they were accused of doing, again, it's settled, so they have not admitted any fault in the terms of their settlement, but they were accused of basically billing for services of IT professionals with the certification that they had specific education experience. And apparently somebody thought that they didn't. And if they did not, then what that would mean is any claims that were submitted to pay for those services would be false. And if no steps were taken to ensure their certificate or those background data points were accurate, then it goes back to the knowledge element. And so 14.75, if there was a whistleblower in, they got a pretty good chunk of change there. And so that signals then to any other would-be whistleblowers that, okay, despite all the risks you take on of deciding to be a whistleblower against your employer, there's potentially a huge payout at the end. And so that's enticing for anybody willing to roll the dice.
Oh yeah, so Moore's Core is another recent settlement this year, and it really plays into exactly what we've been talking about. So in that case, it was another settlement for several millions of dollars, and the allegations are just read like what we've been talking about. So what they were alleged to have done is that they misstated or represented their status in terms of whether they were fully compliant or not compliant, and that became, so I think that's a good case to understand that whatever you put into your proposal or your contract, it is no longer it's not puffery anymore, right? So it's got to be true, right? Because you're putting it and you're signing it, right? So this kind of goes back to making sure that we're now living in a world especially when it comes to cyber, there's going to be, an express certification requirement, and we don't have to guess about whether it's material or not, because you said that this was true, and if it's not true, this can be an outcome. Another thing, in that case is that, they had the unfortunate experience, as alleged, of using a third party to host, the kind of, controlled data that's at issue here, where that, subcontractor was not vetted fully and did not have the, appropriate safeguards or the certification levels. So, they had it up, unfortunately, they had it on both fronts. They had it on their end in terms of their, level of, being ready, and then also not having sufficient diligence done on their vendors and subcontractors. And so, this just kind of, I think, just puts a really fine point that if you're going to be a prime contractor for DoD, you got to make sure that your own house, is in order, but also that your, supply chain, is as well.
And then we look at the Raytheon case. And we think of small contractors and subcontractors who will be getting into trouble for failing to comply with these cyber security requirements. But Raytheon is one of our nation's for sure, 2 or 3 largest government contractors. So if anyone you would think, any company you would think would be sure to be fully compliant, it would be Raytheon, just like you expect it to have General Dynamics or Lockheed or Northrop Grumman. These are our nation's highest and most sophisticated defense contractors. But what happened in that case is they said they certified, they had complied with the cyber security requirements, and they actually failed to. And interestingly, to point out, one big takeaway, not in addition to being it's Raytheon, one of the world's largest, but it's also that they were performing work, and the subsidiary was performing work on unclassified work. It was not classified work. It was not that sensitive work. It was unclassified work on Department of Defense contracts. And so the U.S. attorney who actually prosecuted the case and won the settlement, or earned the settlement, I should say, says this, quote, "Cyber threats have grown in size in recent years, leaving no room for complacency. The government contractor must comply with cybersecurity rules and must, as Dave points out, must be candid about that compliance." And then all the way at the very top of Department of Justice, the Assistant Attorney General at Department of Justice said, "We will continue to hold contractors accountable when they fail to honor their DoD cybersecurity commitments." And just like healthcare fraud and pandemic fraud are the 2 top priorities, cybersecurity is going to eventually replace, for sure, pandemic fraud. And with that replacement comes all those resources that have been used these years since the pandemic to enforce those fraud cases, to bring fraud cases, to prosecute fraud cases, and then go be transferred over to cybersecurity enforcement.
I think, if there's a couple of takeaways here, it's not so much to scare people, but this is just the world that we live in, right? And so I think that, our collective advice is that it is really important to fully understand, especially for, at the management level, to fully understand where the company is, on a realistic basis, on a timing basis as to, when can we get certified, because it is not a quick process just to even do that. And if you're not sure, it is better to not bid on, on a contract, because I don't think the juice is going to be worth the squeeze. That's one thing. I think another thing too is, this area is interesting because when we're talking about, key emulators, as Bart mentioned, it is not, I think that it's actually going to be a little easier to find credible, insiders who work, in the IT department to bring these cases, because they're the ones that are working with the consultants, these third parties. They understand where the gaps are, and so that's an important part, right? So like in any FCA case, the credibility of the relator is going to be critical. Generally, it's going to be like an insider, but for example, like if you had somebody in sales who doesn't have exposure to the day-to-day IT operations or where the company is, that person is going to have limited information, right? And so without getting too much into all that stuff, but like you don't have that same issue when you have the actual person who is working on the IT issues that you're trying to get compliant with, right?
They have insight into every part of the business, right?
Yeah.
And it's the largest class of relators. We've already seen that in the healthcare world.
And any relators council will tell you, when they first get hired on, that one of the things they'll tell their clients is, what documents do you have? And, depending on how much access they have to documents within a company, that can really change the dynamics of a case. And if they come out with emails, on topics and say, hey, we got to fix this, or this isn't up to snuff, that starts to get, better and better for relators council.
Okay.